See, and that's what I'm talking about. It's just drinking.
I was not able to turn myself in. I apologize for that.
Did you call your attorney and say you couldn't make it?
But again, I don't know why it's coming up with that. And I didn't have access any of those days to alcohol or have them in my possession at a no drinking facility. So honestly, I'm telling you, I don't have access to
I'm going to tell you, I'm not believing what she's telling. I just don't think she's going to do what anybody asked her to do.
I can assure you I'll be here on the 1st. I will.
You're just not following through. You don't do what you don't want to do. Well, it doesn't work that way. But at this time, defendant's bond is revoked.
Guys, this one is crazy. A woman walks into Judge Simpson's courtroom already on thin ice and somehow digs herself an even deeper hole. She's out on bond for substance charges, but instead of following the rules, she allegedly tampers with her tether, gets caught drinking, and then stands there denying everything, like nobody else can see what's going on. And here's the problem. In Judge Simpson's courtroom, bond is all about trust, and once you break that, the conversation is basically over. You can literally see the moment her excuses stop landing and reality hits her. And watching her try to talk her way out of it is just painful. So what do you guys think? Was Judge Simpson too harsh or completely justified? Drop your thoughts below, hit that like button, and subscribe for more wild courtroom moments. Let's dive back in.
We are here for PCC and bond violation. I understand the court has received and reviewed the materials that were sent over yesterday.
I did.
Thank you, Your Honor. The only request that we would have when we're discussing those materials, she is staying in a shelter in Livingston County. There is a separate DV having nothing to do with any of this, and there are some cross allegations in that case. So she's just requesting that we not say the name of the shelter if someone is listening on Zoom to where she's staying.
Understood.
Thank you, Your Honor. I believe that the materials that we provided were pretty thorough in terms of where Ms. Brown has been coming from and what her circumstances are in pertaining to the bond violation. So I was wondering if the court had any questions.
Well, I do, because I'm not sure how you provided the materials, but I'm not sure how that relates to the specific allegations of the bond violation. Because what I have, certainly, maybe one might be able to look at the consumption of alcohol, but there was a tampering that occurred for a 12-hour period.
So I am going to let Ms. Brown address that herself with the court. You can explain to him where you're at in terms of the allegation of I had forwarded her the reports the same day. And just so that Your Honor knows, she did intend to turn herself into the jail this morning, but she was unable to get a ride this morning. And so she's here for in-person court this afternoon. So regarding the tamper on 6/23 and then the positive on 6/25, the court is looking for either an explanation or an admission as to these two.
Your Honor, I don't have any clue why those were coming up that way. I know that I was called in to community corrections to have my unit replaced for servicing. And when on my way there, Ms. Julian called me and said that she received a notification from courts that I had a tampering and violation that she was, wanted clarification about. And I had no idea what she was talking about. I told her that I was just called in to do a replacement on the unit itself. I have only been at La Casa AA meetings and with AA people because I don't currently have transportation and a license to get myself to and from these places. And I have not had access or been in the environments of drinking whatsoever. The only events outside of AA are AA events that I've been to, such as there was a sober rave in Royal Oak that I had gone to, but that wasn't even in the dates in question. So I'll stop with that. But I was completely confused. So I had the unit replaced. And while at community corrections, they had told me that I had this tampering and violation 2 counts. And I was in for my reading the week before during this time. And they said that I was all set, good to go. We'll see you next week. And so I was really unsure why I was getting that unless it was due to needing servicing. But I've saying, Your Honor, this is way too important.
Well, hold on a second. Just so that we're clear before you go on with your story.
Okay.
On June 23rd at the 12:56 a.m. time.
Yes, sir.
that's when the tamper is detected
Okay,
with the unit. On the 25th, there isn't a tamper, it's just drinking.
again, I don't know why it's coming up with that unless the servicing part of it needed it. Because at the shelter where I'm currently residing, there's a locked door policy from 11:30 p.m. until 7 in the morning. And I didn't have access any of those days to alcohol or have them in my possession at a no drinking facility. And I was at the facility at both of those times.
She is really not helping her case right now.
She's acting like it's somehow impossible to sneak alcohol into a shelter. But come on, people have managed to sneak contraband into actual high-security prisons for decades. So that excuse collapses instantly. And the way she presents it, like the rules made it impossible rather than her choices, just makes her sound even less believable. The crazy part? Her whole defense hangs on the idea that it couldn't have happened, which isn't a defense at all. It's a dodge. Judge Simpson is literally giving her room to explain herself, and she's burning that opportunity with excuses instead of accountability. I'm not saying she's 100% guilty, but right now, she's offering nothing that builds trust, and every weak excuse just tips the scale further against her. What do you guys think? Is she lying, or is she really just that unlucky? Drop your thoughts below, and let's dive back in.
Documented on camera, I believe they have at the shelter, as well as my sign in and out sheet, and documentation from the shelter staff themselves saying that I was there and there was no evidence of me using. The doors lock at 11:30. I'm a smoker. I come in and I pretty much turn out the lights and go to bed by midnight every night. So honestly, I'm telling you, I do not know unless it has something to do with the servicing aspect of it. I don't have access to there, and it's a couple miles
Does she
away.
want a hearing on this? Because I'm going to tell you, I'm not believing what she's telling me.
Okay.
Then we would request a hearing and we would ask Community Corrections to bring a log of their, not just the violation reports, but if she's been indicating, and she did to me that day, that they called her to Community Corrections to switch out her unit. If there was a problem, and this would have been the unit that was switched out. After this, this would have been the problem unit, is what I'm saying, is that if there was a problem with the unit. So perhaps we'd hearing where Community Corrections can bring their documentation of what they did and when, and the servicing of their units.
How much time would the people need?
I'm emailing Community Corrections right now, and time that works for the courts, I can bring one of them over. Anytime that works for the courts, I can bring one of them over for a bond violation hearing, whatever the courts.
All right, I'll set it for August. I'll set the bond violation hearing. Ask the bond in this case. Now, what I'm worried about is I issued a bench warrant without bond.
I understand, Your Honor. I informed Ms. Brown of that the same day that the court issued the warrant. I did instruct her to turn herself into the jail. I do believe that part toward the end of her letter that was directed to the court expresses that she was emotionally really grappling with coming into custody based on all of her circumstances that were outlined. I have continued to encourage her to turn herself into the jail. She was going to do so this morning, but she does not drive.
Ms. Julian, and I'll just tell you, that's part of my problem. Part of my problem is I know how you operate, Ms. Julian. You told your client, tell them what the right thing to do is, and they don't do it. And then today, or yesterday when we received the information and we understood she was going to turn herself in that morning. And so we were then trying to make sure that she was going to be on the docket at the proper time so we'd see her. So she was just sitting there and she doesn't turn herself in. And my staff, we're going all around trying to figure out where she is. And then I get an excuse she doesn't have a ride here. I just don't think she's going to do what anybody asked her to do. She's just going to make her own call on all this stuff. And I appreciate the circumstance that she's in and have great sympathy regarding that, but I can't let you just go around violating what the court says you need to do.
From Judge Simpson's point of view, this one is a no-brainer.
She's staying in custody until the hearing is over. And honestly, it makes perfect sense. She already proved she doesn't take bond seriously. First, she violated her conditions by drinking, and then she ignored a warrant like she could just skip court and walk around free. And here's the thing people forget. Bond is a deal. The court trusts you, and you show you can be trusted. Break it once, maybe you get lucky. Break it twice and dodge a warrant? That's game over in 99% of courtrooms. Judges see this pattern constantly, which is why they go way harder on repeat violators. And let's be real, even if she sat there silent and respectful, Judge Simpson still would have kept her locked up. Because at that point, it's not about emotions, it's about the system protecting itself. Some people only learn when the consequences hit hard, and this looks like one of those moments. But what do you guys think? Should she get one more shot at bond? Or did she dig her own hole here? Let me know in the comments and let's dive back in.
Your Honor, I do have in the next week before the first medical alcohol treatment with another drug testing per bond order. And I also have general therapy with my counselor, my therapist, all of those appointments, as well as some medical appointments that are all before the 1st of August. I have not left the state, and I was here this morning. I was not able to get here to turn myself in, but I was here for this hearing, and I can assure you I'll be here on the 1st. I really need to make these appointments.
You shouldn't have had to go through whatever. And like I said, it's not like you didn't get the information from your attorney. You didn't get that. I'm reading everything she's sending me. She's doing a yeoman's job trying to represent you and do that. You're just not following through.
I do not have a license, and I'm really sorry that I was not able to turn myself in. I apologize for that. Thank you.
Did you call your attorney and say you couldn't make it?
No, I wasn't sure yet, but
See, and that's what I'm talking about. I mean, Miss Julian makes a representation to us that this is what you're going to do. This is everything. And then the person that's defending you and trying to make sure that the court understands everything about you, you're not even communicating with them to say this isn't going to happen. And then you're not following her instructions.
she said she'd meet me at 1:45, and I texted her at 1 o'clock and said I'd be here at 1:30 and that I would meet her at 1:45. I didn't ask her for a ride, though. You're right.
She did text me. It was after the morning, I want to say noon, that you were not able to turn yourself in this morning and that you would be here at 1:30. So I said that to meet me here since you were going to be meeting me here. So.
How'd you get here this time?
I had a friend of mine picked me up.
I think that what you want to do is you don't do what you don't want to do. And so you don't put the effort forth. And then everybody is sort of just misled as to what you're going to do. Well, it doesn't work that way. Because it puts a whole lot of people out. Because, like I said, we're going on Miss Julian's representation of what she instructed you to do and what you said you were going to do. And you didn't do it. And then everybody's looking around. We don't even know where you are or that you're going to show up at this time. You don't get to make those choices. So at this time, Miss Julian, you can file a motion regarding her additional appointments and other things that she may have to do. But at this time, defendant's bond is revoked, defendant's remand.
Your Honor, thank you. In the meantime, for the record, we are trying to see if we can resolve this case at district court level. So
Okay.
those conversations will continue. Thank you.
Thank you.
Yeah, messing up bond is bad enough, but refusing to come in on a warrant, that's the nail in the coffin right there. Bond is already a tightrope walk, and when you stack violation after violation, nobody's shocked when it finally snaps. Once you show the court you can't be trusted, getting that trust back is nearly impossible. And that's exactly what happened here. Judge Simpson actually gave her chance after chance, but she doubled down on bad decisions until there was nothing left for him to work with.
The thing that really sticks with me is how Bond relies on honesty and compliance. When someone treats it like a joke and hides behind excuse after excuse, it doesn't just destroy their case, it drags down the integrity of the whole process. And what I love is that Judge Simpson never flew off the handle. He stayed calm, he stayed patient, he stayed fair. But once you cross the line, there's no dodging the consequences. At some point, you've got to serve the time. Personally, I think he handled this perfectly. But what do you guys think? And do you have a favorite judge you like to watch in the courtroom? Drop it in the comments, hit that like button, and don't forget to subscribe for more courtroom breakdowns just like this.